All right, welcome everyone. My name is Amy Berquist. I am a senior staff attorney with the International Justice Program at the Advocates for Human Rights. I'm joined by my colleague Lisa Borden, staff attorney with the International Justice Program, and Elizabeth Lacey is providing tech support for the CLE. We're delighted to have you with us. And just in terms of logistics about how this Zoom is working, it's technically a seminar, but we have elevated some of our pro bono attorneys to presenter status, and that's just to make it easier for them to ask questions. These are the attorneys who are currently working on reports with this March deadline. So we wanted to make sure that they can join in and ask questions as and when they wish. If you're watching this and are in the regular viewing mode and you have a question, you can feel free to use the chat or use the Q&A form, whatever is easiest for you. And hopefully we'll be able to get those questions answered. So we're here today to talk about how to write a report for the Universal Periodic Review. And this training is specifically geared toward the 5 teams from Stinson Leonard Street, Perkins Coie, and Deckert, who are working on reports with this March deadline. But the presentation is going to be completely relevant to anyone who is working on a Universal Periodic Review stakeholder report, whether it's about the death penalty or whether it's about other topics. So we're recording this training to make it available, and it will be available also as a CLE on demand. So if you have colleagues you think might be interested in this, feel free to let us know and we'll get the link to them as well. If you want CLE credit, Elizabeth Lacey is the person to communicate with. Her email is elacey, ELACY, @adbrights.org. You've probably already communicated with her at this point, but feel free to reach out to her if you have any CLE questions. We're applying for CLE credit in Minnesota, but I know some states have reciprocity, or you can get a certificate and submit that to your own authority to see if you can get credit. So with that, we will move on and take a look at the agenda for this training. And this training is going to be an hour and a half, just so that you can budget your time. We'll give you an overview of United Nations human rights mechanisms and the Universal Periodic Review, or UPR. Then we'll talk a bit about death penalty issues, like what issues to look out for as you're doing research on your countries. Then we'll focus in on the recommendations part of the Universal Periodic Review reporting process. They're really the most important thing, and sometimes people save them to the end. So we're going to put them earlier in the process so you can think about them. Then we'll get into sort of the nuts and bolts of writing the report and take a look at the template, which I think most of the teams have already received this template, and we'll take a look at it and see how it can help you guide your report writing process. First, I wanted to give you an introduction to the Advocates for Human Rights. I know some of you have already volunteered with us in the past, but some of you might be new to our organization. We're based in Minnesota, and we were established in 1993, and our mission is to implement international human rights standards to promote civil society and reinforce the rule of law. And we do that in a lot of ways, but primarily when we do work on human rights issues in other countries, we work in partnership with other organizations. When we're doing our death penalty work, it's in partnership with the World Coalition Against the Death Penalty, and in many cases, members of the coalition that are based in the countries under review. So for the countries that we're doing these reports with the March deadline, we have St. Vincent and the Grenadines, Trinidad and Tobago, and Antigua and Barbuda. Those are all part of the Caribbean region, and World Coalition partner is Greater Caribbean for Life. So we'll be working closely with them on the reporting process. For Sudan and Tajikistan, those are the other 2 countries we're doing these death penalty reports for the March deadline. We don't have in-country partners, so we'll be relying on our volunteers to do desk research, and if we have any coalition members that have input, we will turn to them, but chances are we'll be relying mainly on our own resources to gather that information. The Advocates for Human Rights has special consultative status at the United Nations, and that gives us a few extra perks and privileges that other non-governmental organizations don't have. And we try to leverage our status to amplify the voices of our partner organizations. So the coalition, the World Coalition Against the Death Penalty, does not have consultative status. So we try to make sure that they are mentioned in our oral statements at the Human Rights Council and written statements. And we also leverage that status to try to build the capacity of World Coalition members to engage with the United Nations. One of the fundamental principles of our work with the United Nations is to link the local and the global. We find that our partner organizations are working to make change in their particular country, and oftentimes using the international human rights system is a way to put pressure on their governments to change when the governments don't necessarily listen to people at the grassroots in the country, don't listen to civil society organizations. They may actually heed what the United Nations says. And so we help bring that link together so that our partners on the ground can use that mechanism to press their governments for change. We're going to provide you with a little bit of an overview of UN human rights mechanisms, just so you know where we're situated with the UPR as part of the overall international human rights landscape. There are a lot of different bodies, and we'll be mentioning 3 of the 4 on your screen today. First is the Office of the High Commissioner for Human Rights, or OHCHR. This is kind of the administrative body of human rights at the United Nations. The Human Rights Council is another body, and that's where the UPR is situated. So that's an important body established in 2006, so a relatively new body. Then we have treaty monitoring bodies. We'll mention those briefly because they are relevant for potential recommendations you'd want to make in your report. And then there are, of course, regional and other human rights bodies, the International Criminal Court, the African Court and Commission on Human and People's Rights are just a couple examples. So a quick overview of the treaty-based mechanisms. We're not going to go into any depth here, but just so that you can understand how you might be drawing on recommendations. And Lisa, am I handing off to you here, or was I supposed to hand off to you a couple slides?
Yeah, I thought so, but that's okay.
Sorry about that, Lisa.
No worries. Yeah, so welcome and thank you again for being with us. So we are going to talk just for a few minutes about the treaty-based mechanisms, the UN mechanisms that derive their power from the various human rights treaties. If you'll move to the next slide. So this is just a quick overview of the topic areas that are covered by the primary human rights treaties. And as you can see, there are treaties covering many topics that may be relevant depending on the topic of your report. And in some cases, multiple treaties can come into play. And as we'll talk about more in relation to the death penalty, for example, while the International Covenant on Civil and Political Rights, prohibition of the arbitrary deprivation of life is the primary treaty that's at issue. The Convention Against Torture is also often relevant, the Convention on the Rights of Persons with Disabilities, and the Convention on the Elimination of Racial Discrimination may also apply. And so as you see here, there are also numerous other treaties that might not turn out being relevant for the death penalty so much, but could be very relevant if you work on other issues. So there are treaty bodies that are monitoring treaties on the rights of children, on workers' rights, on refugees, enforced disappearance, and so on. You can go to the next one. So it's important to keep in mind, each of these treaty bodies does have a treaty monitoring body that monitors the compliance with that specific treaty. And keep in mind that they only apply if the country that you're reviewing is a party to that particular treaty. Each of the treaty monitoring bodies is made up of independent experts who are appointed based on their expertise regarding the subject matter of the treaty. So, for example, the Committee Against Torture monitors compliance with the Convention Against Torture. The treaty body for the ICCPR is the Human Rights Committee, which can be a little confusing because there's also the Human Rights Council, which we'll be talking about a little bit later. So each treaty body conducts a monitoring process in which generally the country reports on the status of its compliance with the treaty. The committee asks questions to which the country responds, and the committee issues what's called concluding observations and recommendations, in which it expresses concerns about gaps in compliance and suggests how the government should take actions to improve. And you'll see when you have a chance to take a look at some of these documents that the language used is very much diplomatic language. You'll never see any really harshly critical language used. So pretty much no matter how atrocious the situation is, it's not going to be called atrocious. The committee will express concern, and if it's really bad, they might express deep concern or grave concern, but nothing really beyond that. NGOs like the advocates get to participate in this process by submitting reports that provide information that the government itself perhaps doesn't share, and suggesting questions and recommendations for the committee to adopt. You can go to the next. So now we're going to turn to the mechanisms that don't rely on a specific human rights treaty, but derive their authority directly from the UN Charter. The next slide. As the name suggests, these differ from the treaty-based mechanisms in that they apply to all UN member countries, regardless of which human rights treaties they may or may not have ratified. And the photo here is just a photo of the main UN building in Geneva, the Palais des Nations, where the Human Rights Council and the other related mechanisms typically hold their meetings. Treaty bodies tend to meet in a smaller building, the Palais Wilson, that's fairly quick tram right away. And then this next one is a photo of the view from the NGO speaker seats inside the Human Rights Council and chamber at the Palais des Nations. When we make an oral statement to the council, as Amy mentioned earlier, we sit here and our statement is translated into all of the various languages that people are listening to through the headsets at each seat in the chamber. Next slide. Some of the activities that are carried out by the Human Rights Council come under the heading of special procedures. And here the council appoints independent experts to provide reports and advice on specific human rights issues. The mandates that are held by these experts might either be country-based, for example, the special rapporteur on the situation of human rights in Myanmar, or thematic, like the special rapporteur on extreme poverty and human rights. The mandate holder could be called a special rapporteur, an independent expert, and some of the mandates are held by working groups, such as the Working Group on Arbitrary Detention. As you can see, there are quite a few thematic mandates. These experts can receive and inquire into complaints, and they often conduct country visits, although they can only do that if they're extended an invitation to do so by the country that they want to visit. And unfortunately, country visits are also limited by funding problems at the UN. The next slide. Now let's turn to another function of the Human Rights Council that is most relevant for the purposes of today, and that's the Universal Periodic Review. This is a rolling process that takes place for every member country of the UN every 5 years. And again, it applies to all of them, regardless of which treaties they've ratified. And any human rights issue that the other member countries want to address during this process can be addressed. Unlike the treaty-based mechanisms and the special procedures, this process is not carried out by experts, but by the diplomatic peers of the delegation whose country is under review. As we'll discuss in a little bit more detail later, diplomats make recommendations to other diplomats about what their countries should do to improve human rights, and the country under review has to respond to those, either by accepting the recommendation or by noting them, which in diplomatic speak means they're rejected. The next slide. So this flow chart illustrates the steps in the UPR process and what happens at each step. In step 1, information needed for the review is collected. The country under review submits a national report, and this is also the stage at which we as an NGO can submit the type of report that this training is about. If the country has a national human rights institution, it will also submit a report. And then the Office of the High Commissioner both summarizes all of the NGO and National Human Rights Institute reports, but it also gathers relevant information from all the other UN bodies, such as the treaty monitoring bodies and special procedures. Once all the participants have had access to all of this information and an opportunity to analyze it, then the next step is the interactive dialogue. This typically all takes place in the Human Rights Council chamber that we showed you a picture of a little while ago. But during the pandemic, there's been a lot of modifications to allow that process to continue. The few people who are there in person, generally including the council president and someone from the delegation of the country under review, are meeting in a larger assembly hall that allows for distancing. And the majority of the statements of the other member countries, which are usually take place in the council chamber, are being submitted on video. So the country under review makes a presentation, usually an opening statement, followed by a few other interventions that are kind of interspersed in between the statements of other member countries. And for the member countries who would like to address human rights of the country under review, they need to sign up to speak. There's a set time period of 3.5 hours. for all of the speakers. So they all sign up, and the time is divided among however many countries there are. When a large number of countries sign up to speak, the amount of time any one country has to make their statement and recommendations can be really short, sometimes under a minute. So they have to be very selective about what they want to say. They usually welcome the country under review and wish it a successful review, and they might make a general statement about some issue. But the most important part is definitely the recommendations, because that is the only thing that the country under review is required to respond to. And they really have to use the specific language we recommend that the country do so-and-so. If they just say, we think you ought to, or, you know, here's some things you should think about, those are things that the country will not have to be required to respond to later. So once the dialogue is over, a draft report of all the recommendations is prepared. Sometimes the country under review might indicate right away which recommendations it accepts or supports, but typically that happens at the next stage when it submits an addendum that shows which recommendations are supported and which ones are noted. It might also make a voluntary commitment to submit an interim report on its implementation of accepted recommendations halfway through the process of implementation. And Amy will mention a little bit more about that later, but it's something you want to look for in preparing your stakeholder report, because it doesn't appear in the same place as all the other UPR information on the website. So you have to look for it. After the council adopts the final report, the next step in the process is for the country to go and implement the recommendations it accepted. And then it will report on its progress when the cycle starts again. So the next one. So we've talked about the stakeholder report and the summaries that the High Commissioner's Office prepares. The other thing that the advocates does in the lead up to the interactive dialogue is to directly lobby the council delegates who will be making recommendations. So internally, we comb through the data about prior reviews to identify which countries are likely to be receptive to the recommendations that we would like to have made. And we first contact them by email. So electronic monitoring, we send our lobbying, we send them our stakeholder report, as well as what we call a one-pager, which is a summary of the major points and the priority recommendations from our report. And then during normal times, when we are able to travel to Geneva, we work the council chamber and talk to delegates and invite them to come and have one-on-one meetings with us to discuss our issues and the recommendations we'd like to see them make. I was very surprised when I first got involved in this work, how eager delegates often are to have these meetings. I was really worried that maybe I was bothering them, because you essentially sneak up behind them in the chamber and tap them on the shoulder and try to get them to come outside. But what I learned is that they're so overwhelmed by the volume of information and the need to narrow it all down to such brief sound bites that they welcome being given the one-pager and hearing about the recommendations that we have formulated for them. And Amy will be talking more later about how we formulate those recommendations to be most effective. We also conduct side events in Geneva where we hold panel discussions and invite delegates and other participants in the session to hear about a topic. One of the silver linings of the necessity of remote proceedings is that we didn't have to jockey for meeting space at the Palais. So we were actually able to hold more side events virtually than we are usually able to do in Geneva. And we had more delegates attending them, probably because the usual crush of activities at the Palais is not going on, and they have more time on their hands and more flexibility to do other things. The next slide. So why do we do all of this? First, it's an opportunity to shine an international spotlight on what, as Amy mentioned, might otherwise only be a local issue that doesn't get noticed elsewhere and doesn't get the attention of the government if only local people are trying to talk about it. And because most UN member countries do care about their international reputation and their relationships with their peers, that international spotlight applies pressure for change. We find that the recommendations do matter. When a country gets a large number of recommendations about a specific issue, that creates more pressure to address it. And that's especially true when the recommendations are high quality ones. They're very specific about what needs to be done, rather than just sort of general recommendations to abolish the death penalty or, to protect the rights of women or something like that. when we make specific recommendations, they can be more effective. Even recommendations that are not officially accepted sometimes wind up being recommended or implemented anyway, or at least partly implemented. So even we want recommendations to be made, even though they might not be accepted, both for that reason and also because the government has to respond to them. It's not so pleasant for them to have to say they reject a pile of recommendations about a human right. And at times, if the recommendation really hits a sore spot, the government might feel compelled to respond to it verbally during the interactive dialogue. And of course, the main goal is to see good recommendations made and accepted, which then leads into the implementation process. And those recommendations give civil society organizations in the country something that they can use to apply pressure to the government at home and that they can try to engage with the government about. The next slide. So before I turn over to Amy to talk about the specifics of preparing the report for the UPR, I'm going to talk just for a few minutes about the types of issues that you would want to be aware of in the context of the death penalty. And since most of you who are attending the training today will be working on that topic, but most of the presentation, as Amy said, is going to be relevant to any kind of topic that you would be reporting on. So what you see here is just a screenshot of the opening of a more in-depth training that Amy and I did recently about UPR reporting on death penalty topics. And if you're interested in seeing that, I think that Amy has provided you with the link via email, and it's available on YouTube. The next slide. So I'll just quickly sort of give a little explanation of each of these issues that you see here. The Human Rights Committee, which again is the treaty monitoring body for the ICCPR, has interpreted Article 6 on the right to life as requiring that where the death penalty is still used, it must be limited to what's called the most serious crimes, and only crimes in which the person being sentenced to death intentionally killed someone else are included in this category. Many countries have laws that allow for the death penalty for other crimes, such as terrorism-related offenses, drug-related offenses, sometimes religious crimes, and so on. So that's a very important thing to be aware of. The mandatory death penalty for any crime also violates human rights standards because it doesn't allow for any consideration of other factors that might be relevant to the person's culpability, what we would in the US would refer to often as mitigation evidence, the ability of the court to take other things into consideration rather than just the guilt of the crime that was charged. Human rights standards also prohibit the death penalty for people who were juveniles when their crime was committed, for people with psychosocial disabilities, and for people with intellectual disabilities. Imposing the death penalty without a fair trial constitutes an arbitrary deprivation of life. So look for all the issues that could impair the right to a fair trial, such as the lack of adequate counsel, coerced confessions, a court system that's not independent and impartial, including, for example, where civilians are tried in military courts. In a lot of countries that where we work on death penalty issues, we do see that, particularly when they're dealing with terrorism-related offenses. Death penalty is often imposed in military courts in civilian trials. Conditions of detention for death sentence people are also an important factor. In many countries, people on death row are held in solitary confinement, and they may be held for very prolonged periods under sentence of death, leading to what has been termed death row phenomenon. Prolonged solitary confinement also constitutes torture. So here is an example of where another treaty comes into play. There must be an adequate right to appeal the conviction and sentence, and to seek clemency. Some methods of execution have been found to violate human rights standards. For example, in some countries, stoning is still a lawful method of execution. It's also important to examine issues about the treatment of human rights defenders in this context, both where human rights defenders are being subjected to the death penalty and also where anti-death penalty activists are being targeted for ill treatment. And with that, I will turn it back to Amy.
Thanks, Lisa. Yeah, and I'll add on that last point, it also includes lawyers. In some countries, lawyers face harassment and threats of disbarment for representing people who are sentenced to death or at risk of being sentenced to death. And so those are all potential issues that we would raise in reports. And if you want more, go ahead and take a look at that video that I put the link to in the chat. And you know, some things apply, some things don't apply depending on the particular country and context. But now we're going to dive into recommendations, and recommendations shouldn't be an afterthought when you're doing a report. I really think it's helpful to start with the recommendations you would like to see and then kind of structure the report around those recommendations. But before we talk about the how-to, I thought it would be interesting for you to see an example of some of the recommendations that are made, how it happens. And as Lisa said, they have very limited time. So you'll see that these recommendations go by fairly quickly. But I'm going to play an excerpt of the Universal Periodic Review of the Interactive Dialogue of Bahrain, which happened in May 2017. And you'll have a chance to see some of the recommendations. You'll see a lot of them are quite similar, and I'd like you to sort of pay attention to the recommendations, see whether any of them stand out in your mind as being perhaps a little bit more unusual, a little bit more distinctive compared with the other ones, or if you think any recommendations sound particularly good. So if you'll give me a moment to get my video set up, I will switch over to that. Let's see. There we go. And I need to share my sound. Okay. And apologies for the dramatic background noise music.
Australia recommends Bahrain immediately implement a formal moratorium on the death penalty with a view to abolishing the practice.
We recommend to commute all death sentences, declare a moratorium on executions, and move towards an abolition of the death penalty.
We recommend that Bahrain commutes all the death penalty sentences and establishes a moratorium on executions.
To reintroduce the moratorium on executions with a view to definitively abolishing the death penalty.
Immediately declare an official moratorium on executions with a view to the ratification of the second optional protocol to the ICCPR and the abolishment of the death penalty.
To promptly undertake a thorough investigation of all allegations of torture and ill treatment, including in the case of the 3 persons executed in January of this year, and to bring the presumed perpetrators to justice.
Suspend without delay executions and declare a moratorium on application of the death penalty as a first step towards abolition.
To impose an official moratorium on the death penalty and to replace the death penalty with a sentence that is fair, proportionate and respect international human rights standards.
Okay. So I'll just, before I switch back to the PowerPoint, there you saw a good set of recommendations. These are part of longer statements, but you'll see they have very limited time to make their recommendations. And you'll maybe have noticed that the recommendation from Switzerland was distinct in my view because it specifically asked about having an investigation into allegations of torture of the 3 people who had been executed earlier that year. So that's a really specific recommendation. It relates to the death penalty, but also is something where you know, Bahrain, like a lot of countries, is probably going to reject any, and did reject, recommendations to abolish the death penalty, institute a formal moratorium. But it's harder for Bahrain to say, no, we're not going to investigate these allegations because, you know, that's something more concrete, specific to a particular circumstance. And having that information in the hands of the delegate from Switzerland really helped them craft a more specific recommendation. So we're happy to hear all of those recommendations, but we particularly like recommendations that seem very tailored to the situation in the particular country. So that's very helpful. I also wanted to say, for purposes of continuing legal education credits, I know that there's at least one person who's listening in on the phone. We need to have a way to know that you are in attendance. So if you can reach out to Elizabeth Lacey at elacey@advrights.org and let her know your name. Also, if you're watching on demand, we're going to give you a code word so that we know that you're watching later on, and that code word is abolition. So If you're looking for credit after the fact, email elacy@adbrights.org and tell her the code word is abolition. Now we'll go on to back to the PowerPoint. Let's see. There we go. And so one of the important lessons for thinking about recommendations is to make sure that there's a connection between any issue you raise in the report, any problems you've identified, and a potential solution. Now with the death penalty, obviously abolishing the death penalty will probably resolve a lot of the issues related to the death penalty, but it might not resolve issues of people being tortured and coerced into giving confessions. You could abolish the death penalty and that problem could still be ongoing. So make sure, to the extent that your research or your work with our partners has identified a problem, you have at least one recommendation that would help solve or alleviate that problem. It seems like common sense, but sometimes we'll have reports that will talk about an issue and then there's nothing in the recommendations that would help address it. So keep that in mind. There are different types of recommendations we like to see during the interactive dialogue, like you just saw for Bahrain. And one is just strength in numbers, having a lot of recommendations to abolish the death penalty, institute a formal moratorium on the death penalty. You'll also see recommendations to ratify the second optional protocol to the International Covenant on Civil and Political Rights, or ICCPR. That's a specific treaty or protocol to a treaty that a country ratifies when it says it is abolishing formally, once and for all, the death penalty. So that's another recommendation. We always suggest those recommendations. They're always good, and it's always good to have a lot of them because that shows how much attention the world is paying to death penalty issues. Another recommendation, and I alluded to this about the Switzerland recommendation you saw with respect to Bahrain, is the recommendation that's an offer you can't refuse. That would be really awkward for the country to say, no, we're not going to investigate these allegations of torture. We're not going to hold people responsible. So those are good recommendations as well to think about. Another example with respect to the death penalty had to do with some advocacy we did with Japan. Japan, like a lot of countries, in justifying its use of the death penalty, says it relies on public opinion. It says the public supports the death penalty and therefore we have to listen to the public, and that's why we're retaining the death penalty. So one of our pieces of advocacy in the UPR, and we had success getting at least one country to make this recommendation, I think it was Australia, was to have the government of Japan engage in a public awareness raising campaign about the death penalty and alternatives to the death penalty and human rights issues related to the death penalty. So it wasn't to abolish, but just to raise the public's awareness, because if you're going to rely on public opinion, the public's opinion should be informed. And Japan is actually quite secretive about the death penalty. Most of the public in Japan don't really know what the practices are in Japan or when executions take place, etc. So that was another offer you can't refuse type of recommendation. So think strategically as you're doing the research in your particular country. Are there certain recommendations that would be helpful, but also be kind of awkward for the country to reject? Another sophisticated type of recommendation is a recommendation that references what treaty bodies have said about the issue. Also, not only treaty bodies, but sometimes a special rapporteur will visit a country, one of those UN special procedures Lisa talked about, and they will have a report that includes observations and recommendations. That's a way to have a very efficient use of the precious seconds that the delegates have at the Human Rights Council when they're making their statement to incorporate a lot of detail in a recommendation. Because the treaty body experts and the special procedures mandate holders, they are going to go into a lot more detail in what they recommend. And that's far more than they would have time, the diplomats would have time to say on the Human Rights Council for, but you can incorporate it into your suggested recommendations to say, fully implement the Human Rights Committee's recommendation on detention conditions, for example. That's a really short statement, but it incorporates by reference all of the detail that's in those concluding observations from the treaty body. So that's another good type of recommendation to think about as you're working on your reports. And also think about recommendations that would push toward incremental change. If you don't think the country is going to abolish the death penalty, think about a recommendation that would say to abolish the mandatory death penalty. That would be a good first step in moving toward abolition. So think about incremental change type of recommendations as well. I'm not going to spend a lot of time on this SMART acronym. You've probably encountered it in a lot of different, I've seen it in a lot of different corporate environments and in grant applications and all sorts of things. But it is important, and the United Nations is backing this SMART acronym to provide some guidance about the recommendations that it likes to see made in the Universal Periodic Review mechanism. Now, that doesn't mean that countries always make SMART recommendations. They might, for diplomatic or strategic reasons, prefer to make a recommendation that isn't so smart, that might be a little bit softer, a little bit more vague. But we, as a non-governmental organization, always want to suggest smart recommendations. And if they want to water them down, so be it. That's beyond our control, but it will really start with something strong. And the SMART acronym stands for, there are a lot of different things. There's some dispute about what the different letters stand for, but for our purposes, specific, measurable, achievable, relevant, and time-bound. Those are the different characteristics of a good recommendation. Specific recommendation gives sort of well-defined action responding to a specific right or human rights violation, like abolishing the death penalty. That's specific, like you're getting rid of the death penalty. It relates to a specific human rights violation. Give you a couple of examples about detention conditions, and these are from actual Universal Periodic Reviews. Algeria's on the list, undertake effective measures to combat poor detention conditions. Now, that's not very specific, like what are effective measures and what are the particularly poor detention conditions that Algeria is talking about? We don't know. But Belgium to North Korea had a very specific recommendation, and this is another way to incorporate the special procedures mandate holders, is to invite the special rapporteur or some other organization to visit these reform institutions to do these assessments, and so that they meet international norms and standards. So a lot more specific on the part of Belgium there. Measurable, can you assess, was this recommendation implemented or was it not? And it focuses on actions that can be taken, not on the results to be achieved. So quick examples, France to Iran, ensure the independence of the judicial system. Well, how do you know that you've ensured the independence of the judicial system? That's not really something that you can measure. Whereas Belgium recommending to Thailand repeal this specific order, saying that civilians have the right to be tried in a civilian court. So that's really specific, tells you exactly what Belgium wants Thailand to do. Achievable, is the state capable of implementing the recommendation? And here we mean like financial limits, not necessarily whether there's the political will. We always want to use the UPR to press countries to have the political will. So we'll give you a couple of examples here. Canada's very ambitious recommendation to Trinidad and Tobago, a small island nation, enhance comprehensive prison and related judicial reform. And you can see all this detail. And it just might not be feasible for a small island nation like Trinidad and Tobago to do everything that Canada is asking it to do. Whereas Switzerland's recommendation to China, publicize statistics on execution. That's certainly something within the power of the government of China to do, and the Chinese government is quite secretive about it. So it's something they can do. They don't necessarily have the political will to do it, but it's definitely an achievable recommendation. Relevant. It has to be a recommendation that's connected to the situation in the country, that would be meaningful for advancing human rights. Usually that's not a problem, but sometimes in the UPR mechanism, we see some recommendations that don't meet that standard. For example, Egypt is a proponent of the death penalty, and so it often makes recommendations along the lines of the one you see on the right, recommending that Afghanistan continue to use its sovereign right to apply the death penalty. Well, that doesn't advance human rights, so that's not really relevant for the mechanism, but Egypt does it anyways. And then time-bound, we generally don't need to worry about for the UPR because the time frame is implicitly within the 5-year cycle of the next review. Some countries will have shorter deadlines. They'll say within the next year or by a certain year or something like that, but just giving a time frame for implementation. So we generally don't need to worry about that for the UPR. So now we'll jump into how to write a stakeholder report. And this is the sort of nuts and bolts of what you're going to be doing. But again, I think it's good to start with a view to what will your recommendations be as you're doing the research and pulling everything together. So just as an overview, we'll talk about sort of the setting the stage steps in the process, planning, gathering information, and then implementation, getting the report done. And then at the end, we'll talk a little bit about best practices and things to avoid. And after that, we'll talk about the template that you should all have. So step 0 is knowing the rules. we're going to be providing you with all of the rules, but if you want to investigate the rules yourself, you can find them on the main Universal Periodic Review webpage. I'll show you that in just a moment. And if you scroll down on that page, there's a civil society engagement link, and that will give the link to all the technical guidelines for stakeholder submissions for the 3rd cycle, which is where we are right now for the Universal Periodic Review. You can look at all of those, or you can just listen to us right now, and we will tell you the relevant technical guidelines. So we need to submit the report in Microsoft Word. It needs to have a cover page, and there are the requirements for the cover page, and there are length limits. So there's a word limit. All of the reports that you'll be working on for the death penalty issues will be joint stakeholder reports. So we get double the normal number of words. We get 5,630 words. That excludes the endnotes, but they also don't read the endnotes. So please don't bury any important substantive information in the endnotes, because it won't be read. Endnotes are really just for citations to show here's where our information is coming from. We can also submit annexes. We don't usually do that, but we might do it if we have a partner organization that's already done a comprehensive report and we want to sort of incorporate that by reference. We would attach that as an annex. So other technical things, number all pages and paragraphs. That's kind of how the UN operates, because they're operating in so many different languages. It's a little unwieldy to rely on page numbers that might be different depending on which language a document is in. So we number all of our paragraphs as well. And we have to, unfortunately, use endnotes rather than footnotes. And that's just a requirement for this process. So that's how it works. More rules in terms of substance. So one of the things they want to see in a stakeholder report is what's happened since the last review. And specifically what they're looking for is what were the recommendations that were made in the last review and what's happened to them, particularly for recommendations that the government under review accepted. What have they done since that last review to implement them? So it's important to identify those recommendations. If it was recommendations that were noted or rejected, we don't need to go into as much detail because the government didn't make any promise or commitment to do anything about them. So you'll probably see there were a lot of recommendations to abolish the death penalty, institute a formal moratorium, ratify the 2nd optional protocol. We don't need to go into a lot of detail. We can just say, 5 countries recommended to ratify the 2nd optional protocol, 7 countries recommended to abolish the death penalty, and this country under review noted or rejected those recommendations. But to the extent that there's a potentially relevant recommendation that was accepted or that was accepted in part, we want to give a little bit more detail about that recommendation. What exactly did they commit to? So maybe there were recommendations related to torture and having a system for people to report allegations of torture and to have the government investigate those allegations of torture. So whatever it was that they committed to, we want to be really clear about that. And in our report, we can talk about what's happened in implementing those accepted recommendations. What challenges has the government encountered in implementing them, or have they accepted the recommendation and they didn't do anything? Do they need assistance from other countries or from the UN in terms of doing next steps? There's also a document called a matrix that the OHCHR, the Office for High Commissioner for Human Rights, creates that kind of thematically organizes the different recommendations into a table. And we have our interns pulling those together for the teams working on the reports right now. We'll get you those matrices in the next week. You can also, in terms of substance, not focus only on the recommendations from the last time around, but also about regressive actions since the last UPR. So, and it's important to know like what the time frame is of your report. The substance of what you put into your report shouldn't go back before the last UPR. That's not relevant. What's relevant is the time period from the last review to the present. So if during that period there were any regressive actions, like more people were executed, they've stripped rights of people to a trial by a civilian court, or whatever else, that information is relevant to put into the report. Progress, some governments will have a UPR follow-up action plan. And so if there's information about whether they've made any, what they've done to implement that action plan, that could be relevant. And also more broadly, other developments since the last UPR. So like, let's say that in the last UPR, there weren't any recommendations on a particular topic. It just wasn't something that people lobbied about. It wasn't something that was mentioned. Like, let's say that there's a country that has the death penalty for same-sex sexual relations. And that just didn't come up during the last UPR. Well, it's still there. It's still on the books. And so we can still bring it up now. It can be just an other development since the last UPR. Maybe they've started prosecuting people. Maybe it's just this has come to our attention. So we can really put whatever we want into the report. We just kind of have to make sure that we're ticking at least one of these boxes as we add the particular substance to our report. In terms of how we support the information for this substance in the report, we're supposed to, according to the rules, provide credible and reliable information on the human rights situation in the state under review. So credible and reliable are important words there. We're supposed to highlight main human rights issues of concern, and these are of concern to us. So we are focusing on the death penalty for this, for example. We don't have to talk about gender-based violence. We don't have to talk about refugee issues. Other organizations are certainly going to talk about those issues. Cover the period since the last review. Not using abusive language, that's usually not a problem for our pro bono attorneys, and they encourage joint submissions when there are organizations that are sort of together on the same theme, and that's why we're working with the World Coalition on these death penalty issues. Other rules relating to substance. Now, the stakeholder guidelines say that we're supposed to prioritize firsthand information, the stakeholders' own views, findings, and conclusions. And we're supposed to include secondhand information only if necessary. Now, there's a little asterisk I put by that because oftentimes that's the only information we have. So we'll be relying on you to do desk research, especially for countries where there's not an organization on the ground that's an abolitionist organization that's there gathering information in Sudan or Tajikistan. We just don't have other access to information, so we will be relying on secondhand information. And even with the Caribbean countries where we have Greater Caribbean for Life, they're relying on secondhand information as well through their networks. So it's okay to rely on secondhand information. If we do have access to firsthand information, by all means, we want to include that. But there's no penalty for relying on secondary sources. We also want to offer smart recommendations. That's in the guidelines. And I'll talk about the themes when we get to the template, but we do want to link recommendations to themes. And they don't want you to include a lot of rehashing of what United Nations bodies have already said. There's already a separate document that covers that, so you don't have to deal with that. It's good for you to know and good for you to incorporate into your suggested recommendations, but you don't need to put that into the substantive body of your report. Confidentiality is probably not an issue for the reports we're doing now, but for those of you who are watching and maybe working on other reports, it might be something for you to think about. The stakeholders, meaning the organizations listed as the authors, their identity is public and the report itself is published on the UN website. We can keep our sources confidential, so sometimes the Advocates for Human Rights will use information about its clients' experiences, clients who have fled persecution in their home countries. So we can use that information and keep the identity of our clients confidential when we put that information into a report. And there's guidance specifically saying don't refer to individual cases if it's going to jeopardize concerned individuals. There is a reprisal system if anyone individually or as a non-governmental organization faces reprisals from the country being reviewed based on their advocacy in the UPR. There's a mechanism to help address that. And that is a real big concern for our partners in some countries. So now we get back to the steps. So the first step is identify your expertise, and our expertise collectively for these reports coming up is the death penalty, and our partner organizations' issues are all of those issues related to the death penalty that Lisa talked about and that are in that YouTube video. Our advocacy goals, we want to work toward abolition in the country that's being reviewed. So obviously having them abolished would be a great reach goal, but there might be other intermediate goals that you can help us identify. And then figure out what our resources are, who's on your team at the firm who can help, what can you do, and then also enlisting our partners like Greater Caribbean for Life to the extent that we have those partners. Identify our allies. So that's the World Coalition Against the Death Penalty, the Advocates for Human Rights. So we are, the World Coalition is ready to sign on as a joint stakeholder for the report. There might be other organizations through your research that you identify, and maybe we would want to reach out to them to ask if they want to sign on as another co-author of the report. There is power in numbers if we have more organizations signing on. Sometimes it's just not feasible. Sometimes there just aren't anti-death penalty organizations on the ground in the country that we would want that are there to link into our work. Then you want to identify the rights. And for death penalty issues, it's pretty straightforward. I think Lisa gave a good overview of that. But the rights that we can draw on are in the Charter of the UN, the Universal Declaration of Human Rights, any pledges that the country has taken when running for the Human Rights Council or other contexts, and then applicable international humanitarian law. You also have the standard rights in human rights treaties, in the general comments that the treaty body experts issue, the concluding observations that Lisa talked about, where after the review process is over, the treaty body experts say, here's what we're concerned about, and here are the recommendations we're suggesting you implement. And as Lisa said, the treaties a country has not ratified are also fair game. So we oftentimes will have a country that retains the death penalty that hasn't ratified the Convention Against Torture. So that can be a recommendation, is to ratify the Convention Against Torture, or if they haven't ratified the International Covenant on Civil and Political Rights, which specifically talks about the death penalty, to ratify the ICCPR as well. So those are great recommendations and good to know in advance what a country's ratification status is. So then you want to review the procedural history. You want to read up on what's happened in the last UPR with respect to these rights. There are various documents, and now I'll share my screen to show you the web page that we typically go to. You're going to look for the report of the working group, the addendum, an interim report if there is one, as Lisa mentioned, and we'll enlist our interns to try to dig those up for you, and the matrix if there's one available as well. So now I'm going to share a different screen with you and show you, let's see. There we go. So what you should see now is the main webpage for the Universal Periodic Review. There are useful things to navigate over on the left-hand side, but the most important one for you is going to be that documentation by country link on the left. And if you click that, it will take you to a page that lists all the countries in the world. And you can take your pick, find your country on that list. And I think for our purposes, Myanmar is a country that retains the death penalty. It was just reviewed, had its interactive dialogue on Monday. So we'll go to Myanmar. And all these pages look more or less the same. So you'll see the third cycle, the date of consideration was this Monday. And this is all the information for the third cycle. You have the national report, the compilation of UN information. That's all anything a treaty body has said, or a UNICEF or other UN bodies. And then the summary of stakeholders information, that's the OHCHR summary of all the different stakeholder reports that were submitted. And sometimes for some countries, there are hundreds of stakeholder reports. And that's important to think about because the delegates we want to lobby on the Human Rights Council floor, they're not going to read all of those stakeholder reports. They're probably going to read this summary document, which is about 10 pages long. So we want to, and we'll talk about this in the context of the template, we want to try to make sure we are mentioned as much as possible in the summary of stakeholders information. And the template is designed to try to increase the likelihood that we'll get cited in various parts of that. This is all the information leading up to the review that just happened, but what you're going to be looking at is what happened in the second cycle. That information the third cycle information won't be there yet for the countries you're working on. So for the second cycle, we can see when that review happened for Myanmar. It was in November 2015. And then we have the most important documents are going to be the report of the working group, which you see here in all the UN languages. The addendum, the report of the working group is a document that summarizes what happens during the interactive dialogue. So it will summarize any statements the government made, and that can be really useful if you want to see, like, what position did the government take on the death penalty? Did it say anything during that 3.5-hour session in the last review about its position on the death penalty? Did it give any reasons for having the death penalty? Like I mentioned with Japan, relying on public opinion. So it's useful to look at the report of the working group for that purpose, to see whether the government went on the record about the death penalty, but also, and more important, it includes all of the recommendations that were made during the interactive dialogue. So verbatim what those recommendations were as delivered on the floor of the council. The addendum is typically the document where the state under review responds to those recommendations, saying we accept these recommendations, we note these recommendations, we accept these recommendations because we think we've already implemented them, or they may provide some explanations. That also can be a really useful document for you to dig into what the government's position is on a particular issue. So that's the addendum document. So the report of the working group and the addendum are the two main documents you want to look for. And here you also see the matrix of recommendations available on that web page as well. So those are the most helpful documents, I think, that you can find from the second cycle reviews, and you find them just as I've shown you there. There we go. All right, let me get my navigation back up. So then in terms of reviewing the procedural history, you also want to read up what has happened with the other human rights mechanisms, like the treaty bodies, concluding observations and lists of issues, the country visits by special procedures mandate holders. Those are all documents that our interns are gathering for you, and we'll send those off for you so you don't have to have the headache of navigating the treaty body system and the special procedures, tracking down special procedures reports. But those are useful primarily, not because you're going to draw substance from those reports, but because you could use those reports as part of your recommendations, incorporating those by reference into your recommendations. Then you're going to clarify your role. This is, pretty straightforward for death penalty issues, but it might be a little bit more nuanced on other reporting that we do. How do we shed more light on these rights and related issues? Do we have on the ground information, firsthand accounts, or do we have our own analysis? Because we are experts on the death penalty, we can look at the law and say where the law deviates from international human rights standards. We have more specialized knowledge. And then we want to set our goals. So our goals are the interactive dialogue, as we showed you with Bahrain. And during that interactive dialogue, countries can pose questions, and we invite that as well. That's a good thing. But our primary goal is to get those delegates to the Human Rights Council to make recommendations on our issues. So that's our goal. And we want to make sure if we have a partner organization on the ground, like Greater Caribbean for Life, we want to consult with them early in the process to say, what would be some priority recommendations that you would like to see out of the UPR beyond abolish the death penalty, institute a formal moratorium, ratify the second optional protocol? What else would be helpful to move the ball forward, maybe some incremental recommendations that would be of use in the process? Then you want to have your work plan. So you're going to connect the targeted your goals and the relevant information that you have. Then start with gathering information. Right? Remember that you want to have credible and relevant sources. You can collaborate with the partner organization if we have one to try to track down additional information and make sure that your information is recent, that is no older than the last review. Keep in mind that the Advocates for Human Rights and the World Coalition may also want to use the report beyond the UPR process. So that's, there might be additional nuggets of information you'll want to include, even though they're not 100% relevant to the UPR. It might be good to include them for other purposes as you're doing your research. Then, of course, you're going to write the report, set up your writing team, however you prefer to do that, whether it's you, whether you're doing this as a solo project or whether you have a team that's working on it at your firm. Put together that information you've gathered, incorporate those targeted recommendations, and again, no abusive language, and don't discuss the procedural history about what happened with the treaty bodies, treaty ratifications, et cetera. That's going to be already in front of the delegates in another document. The next couple of steps are more in the Advocates for Human Rights hands. You need to finalize and submit your report. We will do the finalizing the report. We will do the submission. We have to submit it on an online platform, and we will be doing the recruiting of additional sign-ons. But as you do your research, if you come up with organizations you think we should invite to sign on, and we typically will do that if we rely heavily on an organization's reporting or information, we'll want to give them credit. So do keep that in mind and let us know so that we can invite them to sign on to the report. And then we engage in advocacy. As Lisa said, we do advocacy with diplomats. We'll do advocacy with the government to try to get them to accept recommendations. We're going to be doing some advocacy with the Biden administration because the United States had its Universal Periodic Review in November of last year, and there were some important death penalty recommendations, and we want to see if we can get the Biden administration to accept them by the March deadline. And then also advocacy for implementation of accepted recommendations as well. And we use our reports for education and outreach as well. Finally, just some good practices for stakeholder reports. We find it's really helpful to frame your issue in terms of here's what the government position is, or here's what the law says, and here's what's actually happening. Because oftentimes the government's position is not entirely accurate. It might shade the truth. It might just be an outright lie. But it's good to give the diplomats first the information, like here's what the government says, and then fact check them, then give them the actual what's going on the ground. Also, it's helpful to use examples or stories to highlight problems. Sometimes we can't find a whole lot of information, but we can find a really good news report, for example, about a particular trial. And we can use that to highlight gaps in the law or barriers to implementation. If they say, oh yes, everyone has the right to counsel, but a news story shows that actually the attorney was appointed, 15 minutes before the trial began, that shows that they may have a right to counsel, but it's not going to be quality counsel, quality legal assistance, because the lawyer had no time to prepare. Endnotes we've talked about. Avoid lengthy procedural history. This is actually quite refreshing, I think, for some lawyers. You don't have to dig into all of the nuts and bolts about what happened and when. You want to hammer home on the substance of whatever the human rights issues that you've dug into. You don't need to provide a lengthy discussion of the substance of the particular rights. You don't have to go into, and it's discouraged to go into an explanation of what Article 6 of the ICCPR says about the right to life and the prohibition against arbitrary deprivation of life. The diplomats aren't going to talk about that in their statements. They know that that's an issue, but we don't need to sort of lecture them on that. What they really want to know is what's going on the ground and how can they make recommendations that will help. So also avoiding vague recommendations. So now we'll jump to using the template, and I have sent out to most of the groups an updated template that's death penalty specific. So it has the boilerplate about the Advocacy for Human Rights work on the death penalty, and also the description of the World Coalition Against the Death Penalty. So you should use that template if you have it. If you're working on a report and don't have that yet, let me know, or let Elizabeth Lacey know, and we will get that to you. But I did want to go through the template and just kind of explain what's there and why. This is the cover page, and as you saw back from the rules, we have to have a cover page, and the words in the cover page don't count toward the word limit. But the cover page includes sort of things for you to fill in: what the state party is, what the session number is, what the dates are of the session, when we submitted the report. You can save that because we won't know until we actually upload it. But then there's a description of the Advocates for Human Rights and the World Coalition Against the Death Penalty, and then other reporting organizations if available. So with Greater Caribbean for Life, for example, we would add that to the cover page. So you'll want to, if I'm putting you in touch with Greater Caribbean for Life, you want to make sure that you get their description for the cover page as well, and ideally get their logo, and we'll add that in along with the World Coalition's logo to the cover page. So that should be fairly straightforward, but how do you find out what session it is, and how do you find out what the dates are of the session? Well, you go back to that webpage that I showed you, and there's a tab called Civil Society Engagement. And if you click on the Civil Society Engagement tab, you can scroll down to see where your countries are listed. So for the 5 countries we're talking about today, which includes St. Vincent and the Grenadines, Sudan, Tajikistan, Antigua and Barbuda, and Trinidad and Tobago, those are all the 39th session. And the March 25th, 2021, that's the deadline that we have for submitting the report. You'll have an earlier deadline for getting it to us so that we can review it and circulate it to the World Coalition for its validation. But that's March 25th is the final deadline for uploading the report, and it's the 39th session. And you'll notice it just says the session is October to November 2021. It doesn't actually give those dates. There's another page, unfortunately, where you have to dig around to find the actual dates. If you go to the sessions link, you'll see there's a list of upcoming sessions, and it tells you the dates of the upcoming session where these countries will be reviewed. That 39th session will be from November 1st to the 12th, 2021. So later this year is when the actual Universal Periodic Review interactive dialogue will happen for all of those countries. And you notice there's a big gap because the reports are due in March and the review doesn't happen until November. And that's another important thing that the Advocates for Human Rights does, is we provide updated information between the time the report is submitted and when the actual review happens. And we usually don't start our lobbying in earnest until about 2 months before the review starts, because there could be new developments, especially with the COVID-19 situation. You don't know what's going to be happening. There might be changes in practices or procedures, and we want to make sure we're able to provide updates, but we also want to make sure we submit the report on time as sort of our foot in the door to do that advocacy. So that's how you find the session number and the dates for the session. Then we have sort of the first part of the report, an executive summary I think you're all familiar with, but if you look at paragraph 2 in the template, it lists a lot of different death penalty issues to consider. That's sort of a summary of the things you see in the YouTube video and what Lisa talked about earlier. Those are all certain things, you know, topics you may want to consider in your country depending on what your research reveals. And then the next section, part 2 of the report, is background and framework. In the background and framework section, we don't want you to engage in any argumentation. This should be sort of dry recitation of information. The first part of the background and framework section is what happened in the last UPR. In this case, what happened in the second cycle UPR. What were the recommendations? Were the recommendations accepted or noted? And a scorecard, were they not implemented, partially implemented, or fully implemented? But we're not going to do an analysis here. So it might be that Trinidad and Tobago received 15 recommendations to abolish the death penalty or institute a formal moratorium. Trinidad and Tobago noted all of those recommendations and has not implemented them. That's all you need to say for that particular section. And depending on what your research reveals, you may want to have a lot of different sections under the UPR, what happened during the last UPR. You might want to have one section on the death penalty, of course, but if your research reveals that there's a use of torture that might apply in capital cases, then you might want to have a separate subsection under the background that covers torture-related issues. So looking at the torture-related recommendations, whether they were accepted or noted, and then just stating whether they were not implemented, partially implemented, or fully implemented. So the number of different subcategories in part 2 will depend on the issues you uncover when you do your substantive research. The second part of part 2 is the domestic legal framework. And this is just sort of a dry legal recitation of where the death penalty is on the law books, what are the crimes for which the death penalty applies or can apply, who is eligible and ineligible for the death penalty, those things that Lisa talked about at the beginning of her coverage of the different potential death penalty issues. Also, you might want to include things like if there's a prohibition against torture, if there are remedies for torture, if evidence obtained via torture is excluded at trial, any sort of statutes, laws, policies relating to detention conditions or any other issues, put those in the domestic legal framework. That's just where we set forth what the Constitution and the statutes, laws of the country say about the issues we're going to be talking about in part 3 of the report. So part 3 is really the heart of the report. This is where all the substance goes, and you want to focus on implementation of any accepted recommendations and developments since the last UPR, limiting your time frame to whenever the last UPR was, which is 2016 in this case, to the present. The weird thing about this section, and this distinguishes UPR stakeholder reports from other reports that we do to the UN, is the rights or areas. The reason we have all of these rights or areas listed in the template is that this is how the Office of the High Commissioner for Human Rights approaches its summary document. So when the OHCHR summarizes all of the potentially hundreds of stakeholder reports it gets, it uses these categories or topics or buckets to organize its report. So we are organizing it the way OHCHR organizes it to help them read our report and to help increase the chances that they will incorporate our report into multiple sections of their summary report. So it's basically to increase our chances of having more visibility for our issues in that summary report. A lot of these topics are not relevant to the death penalty. Like if you see right or area number 1 is the right to self-determination. That has to do with the collective right of indigenous peoples to determine their own governance, destiny, property, etc. So that's not generally relevant to the death penalty, but that's just the first one on the list. And so you'll see there are a whole bunch of topics that may or may not be relevant, and just if it's not relevant after you've done your research, then just delete it and just stick with the topics that are relevant after you've done your research. So some potentially relevant topics, and this is, there might be other ones you see on the list. So just as an example, like gender-based violence, violence against women is a topic, and usually that's not relevant for death penalty issues. However, Bangladesh is contemplating adding the death penalty for rape and sexual assault. So we could also mention that under the writer area having to do with gender-based violence, to say that there are heightened levels of gender-based violence, rape is a growing concern, and in response, the government has proposed adding the death penalty for this offense. We would also talk about it under the death penalty, say that rape is not a most serious crime. That standard under international human rights law, a crime is most serious if it involves an intentional killing by the person being sentenced to death. So rape doesn't involve an intentional killing. Same with drug-related offenses. A lot of terrorism-related offenses don't require as an element of a crime an intentional killing by the person being sentenced to death. So these are the different topics that might be of interest. Acceptance of international norms can be just what treaties have they ratified? Have they ratified the Convention Against Torture, the International Covenant on Civil and Political Rights? Cooperation with special procedures. It might be relevant. Have they invited the Special Rapporteur on Torture to visit the country, for example? Human rights education and training, especially on issues related to detention conditions and torture. Do they train prison guards? Do they train police officers not to use torture, about what human rights standards are that guide their work? There are two different areas that might be relevant to the death penalty. One is right to life and the other is the death penalty. We generally put everything in the death penalty rather than right to life. We don't want to duplicate ourselves, and there's just, when you have something, a category that's more specific, put it there. But the prohibition against torture, that would be where you would talk about coerced confessions. It could also be where you talk about other related issues of torture, but you'll see also conditions of detention. If detention conditions amount to torture, we'd probably put that information under conditions of detention. Freedom of opinion and expression can also be, depending on the context of the country, it could be that people are prosecuted for terrorism-related offenses because they've criticized the government. So you might put that under freedom of opinion and expression. Administration of justice and fair trial. Those are the things Lisa talked about in her discussion of those issues. And human rights defenders, that's where we would put issues about non-governmental organizations being targeted for advocating against the death penalty, or for lawyers facing harassment or sanctions for representing people under sentence of death, or advocating against the death penalty. So it's fine to sort of be liberal in the number of rights or areas that you include in your report. And sometimes you'll have the substance of it in the death penalty section, and then you'll just have a brief 1 or 2 sentences in another section to say, as we discussed in paragraphs 3 through 7, this is also an issue here, just to make sure that we've flagged it in different places for the OHCHR people who are putting together the report. So you don't have to repeat yourself, just cross-reference and put the substance of the work wherever it seems to fit best. Then the recommendation section. And I said we end with the recommendation section, but I wanted to begin with the recommendations as well, because they're really the most important part. Make sure that any issue you've raised in part 3 or in part 2, when you've discussed the legal background in the country, that you have a solution for it in a recommendation. Try to make sure you have SMART recommendations. And you can have as many recommendations as you want, but recognize that people have very limited time. So think about how to make efficient recommendations, as I mentioned before, incorporating by reference concluding observations from the treaty bodies, or recommendations that are made in the reports after country visits by special procedures mandate holders, for example. So that's sort of an overview of the template. The template is already formatted with the numbered paragraphs and all of that, but I know some of our volunteers kind of struggle with, they've typed up what they have in a different document and they want to paste it into the template, and they struggle with that. And if you're not familiar with Format Painter, I hope it will now become your new best friend. So if you've pasted in this this thing that doesn't match the formatting, it doesn't match the paragraph and all of that, what you can do is just put your cursor, or click your cursor into a paragraph that does have the formatting you want, click the Format Painter, and then select the paragraph that you want to be formatted the way the other one is, and then that will magically give you all the formatting. So that's a great tool to use as you're putting information into the report. The only caveat is that if you have footnotes in what you've copied and pasted, the footnotes will no longer be superscript, they will be full size. So you'll need to make those footnotes superscript again. But that's also a very useful tool for using our template. And at the end of the template, we give you some suggestions for sources to look at. And we also give you some suggested citations. And these are prepared by our interns who generally have the job of going through the draft reports and sort of standardizing the citations. The UN doesn't really use Blue Book formatting. So I would say don't stress out too much about the formatting, but do provide full citations for every source that you use. So don't use IBITs. Sometimes when we get a draft, we need to juggle things around, we need to move things. And so it can be really frustrating to have a supra or an IBIT and get those sources lost and having to go back to the original draft that we looked at. So please just copy and paste the full source citation into every footnote, and please footnote every sentence that has substantive information. Ideally, you'll be using paragraph numbers for any UN documents. And if it's a source available on the internet, please give us the URL as well. So that's the end of my little tour of the template. And now we have 15 minutes for your questions. So those of you who are part of the reporting teams from Stinson, Perkins Coie, and Deckert, you can just unmute yourselves and ask right away. And those of you who are otherwise attendees, feel free to use the chat or the Q&A function. And we would love to have your questions and input. You also have my contact information up on the screen. And a reminder, if you're looking for continuing legal education credit, Elacy, E-L-A-C-Y at advrights.org is the person to ask. So we'll open it up now for questions. How can we help you be better prepared to do a report?
Hi, this is Linda Goldstein from Deckard. I just have a technical question. So if we have a primary source, like an interview that we're relying upon, how do we footnote that? How do we make it available so that the readers can consult it if they want to?
So in terms of footnoting it, or endnoting it, I guess in this case, it depends on whether the interviewee wants to remain anonymous. So if the interviewee is fine with them being mentioned, then you can go ahead and note the interview with so-and-so, just like you would with a Blue Book source citation, the date of the interview, the means, was it by telephone or Skype or whatever. And then what we would want as the advocates for human rights, we're the ones who are listed as the author. So we would want from you, if you have any record of that interview, you could just send us an email to say I had, or this could be in notes that you send along with the report, whatever is easiest, so that we would have just some documentation that you conducted this interview with this person and any bullet points of information that you gathered during that report, so that we can put that in our archives along with this report. We generally don't make those things available to the general public. We would put after the endnote citation, we put on file with the Advocates for Human Rights. And then if somebody wanted to push further, then nobody ever has, but if they did, then we would have to make the decision about what we were comfortable sharing based on whatever you told us. Did that answer your question, Linda?
Yes, that's fine. Thank you.
Okay, thanks. And I also have up on the screen a link to our toolkit called Human Rights Tools for a Changing World. Chapter 9 focuses on advocacy at the United Nations, and there's a section in there about the Universal Periodic Review, so you can take a look at that. For those of you who are part of the report writing teams from the 3 firms, I think I've given you a link to Chapter 9 and the specific page numbers for you to look at. But for the rest of you, that's a good resource as well. Soon to be updated. Lisa is working on that project. And maybe while we're waiting for more questions to come in, Lisa came to the Advocates for Human Rights having done a lot of these reports on a pro bono basis for the advocates. Lisa, what tips and tricks would you share with attorneys who are working on a UPR report for the first time?
Wow. Okay. I would say that if you can look for, if depends on the country whether this would be available, but if you can look for local reporting, I think you often find, you know, some real details there that you won't find in like the national reporting that was listed on the list of resources. I often find that it's very difficult to find the actual, you know, links to laws and so forth, and particularly for things that are changing in the law. But if you look to see if the country has, you can look on the country's legislative websites. Oftentimes they are in English, or they're, you know, the English translation available, or the country's national human rights institution will often have the information that you might be looking for about whether there's any, you know, sort of ongoing push to change the laws that you might want to be familiar with.
Yeah, that's a good point. You know, some countries are sort of sometimes moving in a bad direction. Like the Philippines has abolished the death penalty, has ratified the second optional protocol, but there are a lot of moves in their Congress to reinstate the death penalty. So those are things that we would include in our report, even though it's not part of the law right now. The fact that, you know, more than a dozen bills have been introduced in the Senate to reintroduce the death penalty would also be something that we'd want to include in the report. And yeah, it can be tricky to find the sources. And you also, you know, we want to make sure that the sources we're relying on are credible. And so to the extent that we have a local partner, we would tend to say, okay, we found this website. Is this sort of a credible journalistic outlet where we're finding these sources? And they would probably have a good sense of, yeah, that reporter is actually really good, and what they're saying is consistent with what we've seen on the ground. If we don't have a local partner, we just need to be a little bit more cautious in citing sort of local news sources to make sure that those have credibility. So we might try to cross-reference multiple news sources. It can just be tricky. Sometimes there just aren't good sources of information. I know, Lisa, you had to do a lot of work on our Somalia report, and, you know, maybe you want to talk about that experience, like how you tracked down, how you assessed the credibility of the sources you were looking at for that.
Yeah, so the issue in Somalia is that there are multiple different judicial systems that are all being used in different parts of the country, that may or may not overlap in different regions, and it was really, really difficult to figure out you know, where each judicial system applied, and what kinds of cases what kinds of death penalty cases they were handling. So I did a lot of local reporting digging, as well as checking. There are a number of, you know, organizations in the region that somalian information, so I spent a lot of time on their websites. And then we were very fortunate to have a connection here to a Somali American lawyer who's been actually involved in some of the legal reforms in Somalia, who was able to, you know, go back through the information that I had found with me and taught me through, you know, how accurate those different sources were, and the way he viewed what they sort of portended for the near future in Somalia.
Yeah, and if you're in a position where you feel like you would really like to double check your information with somebody in country who kind of might have more on the ground information, but you can't find someone, another thing you can do is take a look at the stakeholder reports that were submitted for the last review. And, you know, chances are, if there was a death penalty report, it was probably authored by the World Coalition and the Advocates for Human Rights, but it's possible there are other organizations that have done some advocacy. And I'll screen share right now and show you how to dig around and find that using Myanmar as an example, which might not be the best example, but we'll give it a try. Let's see, share. So if you come to the summary of stakeholders information document, you'll see this footnote 3. That's the magic place where all of the stakeholder reports are submitted, are uploaded to the internet. So when we say they're public, you have to know where to click, but all these reports are public. And here you can see for Myanmar, all of the reports that were submitted this time around for the Universal Periodic Review. So you see all the different organizations, and then you have, these are individual reports, and then you have joint submissions where you don't know from looking at it who actually wrote the report. So that might be a little unwieldy to click through each report on its own. So one thing you can do is instead go to the summary itself and open up that report, the summary from the OHCHR, and then you can just do a search for death, as in death penalty. So this says AI and JS8 noted that the death penalty remained part of the legislative framework and courts continued to impose death sentences. So we want to look at AI, which is Amnesty International, and JS8. JS8 is one, and then the next paragraph, JS8 highlighted that people in detention were subjected to torture. So that JS8 might be particularly relevant as well. And so that's, and then when we go down to the bottom of this, it says joint submission 8 submitted by Advocates for Human Rights, Minneapolis, United States of America, World Coalition Against the Death Penalty, and the Anti-Death Penalty Asia Network. That's our another coalition member. But you might not encounter the Advocates for Human Rights. You might find some other organization that's talking about the death penalty in that summary, and that might be, you could reach out to that organization and say, hey, I'm gathering information for the upcoming Universal Periodic Review. I'm doing a report. Could I interview you on an anonymous basis if you like, to try to gather some information? That might be another way for you to get some additional information. What other questions can we answer for you? Lisa, what's the most intimidating part of doing a UPR report if for the new attorneys you were supervising, or what do they have the most hiccups with dealing with?
Number one, formatting. But beyond that, it's just, a matter of being unsure about whether you're finding the right legal sources in the country, especially for countries where it's not, like US laws are very easy to find, but in some countries they're not easy to find, and making sure that you're interpreting them correctly. Sometimes you have to find a translation that may or may not be the greatest translation. I think those were the things that, like, people were nervous about whether they had the right information. You have to spend some time tracking down, multiple sources to see if you're coming up with the right information.
Yeah, and that it can be really helpful for formulating succinct recommendations if you have the specific article, the specific provision in the penal code or whatever criminal procedure code, because you'll remember that Belgium recommendation that we looked at, they reference repeal this particular thing. So we need to know that we have the exact correct reference so that we can make that really succinct suggested recommendation. So it's important to get those details to the extent we can. If there's a provision that calls for a mandatory death penalty, we want to be able to say, repeal this particular thing and replace it with a provision that allows judges discretion to sentence somebody to a penalty other than death, for example.
And the other thing I would say is that if there was a number one problem that I noticed in drafts I got from attorneys that were working on reports with me at my law firm, was that would have been like citing to a source and making a general statement with a citation to that source, rather than being really specific about what you're drawing. Like, if you read an article and it talks about a particular, particular death penalty cases, that happened in the country, and then you just draw your conclusion about, rights violations from those cases without describing in the body of the report something about the cases themselves, the facts that you learned from that article. It's difficult, I think, for the people who are looking at the report to really understand why you drew that conclusion. And again, as Amy said, they're not reading the footnotes, and they're certainly not going to source documents. So you have to remember that you need to, whatever, factual underpinning of the conclusion you want to draw, if it's important enough to make that conclusion, you need to let them know why you drew it.
Yeah, I would say, you know, a good starting point for your research is going to be the annual Amnesty International reports on the death penalty. Just go back and look at the last 4 years, I guess. The most recent report, they're usually released every April. So the April 2020 report covers all of 2019. So just go back and look at 2016, 17, 18, 19 for you. And if you just do a Control F search for your country, you should be able to come up with some tidbits about whether there were any new people sentenced to death, whether there's anyone on death row, what those changes are over the past 4 years. And then the Cornell website, which is in your template, is also another good source to get started on your research. I also highly recommend the US State Department reports. They do country reports for every country in the world every year. And sometimes they have really good coverage of fair trial issues, independence of judiciary issues, access to counsel issues, detention condition issues, depending on the context and what the priorities are of the US Embassy in the particular country. They can be really useful reports. Well, it looks like our hour and a half is up. Those of you who are currently working on teams, you should have my contact information. So feel free to reach out to me with further questions, or if you want to do a follow-up meeting or something after you've done some research, or if you want to have specific questions answered, I'm happy to do that. For those of you who aren't currently working on a report, there are 3 deadlines throughout the year. The next deadline is going to be in June, and then a deadline in September, early October. So we will probably be looking for additional volunteers to work on these reports in the future. So if you heard about this opportunity through your pro bono coordinator at your firm, let them know that you're interested, you've been through the training, and you would like them to sign up when they get the next request for volunteers to help out with these reports, because now you're like 2 steps ahead of everyone else. You've already been through this training, you know what to expect, and you're fired up and ready to go. So we really appreciate the pro bono support that we get. I think last year for the UPR alone, we submitted over 40 different reports on a lot of different countries. So we couldn't do it without all of you and your support, and we're here to provide you with the training and assistance that you need to pull together those reports and we get them polished up and submitted. So thanks so much for helping us with this important advocacy that really helps our partners and helps, in the case of the death penalty, to press countries to move toward abolition. We really appreciate it. Thanks, everyone.
Thank you, everyone.